Mr. Chief Justice, and may it please the court, petitioners have made very clear this morning that they're trying to ask you to overturn not just Colorado II, but really 50 years of campaign finance law. This is a highly politicized case, and I think the first place to start is with jurisdiction. No petitioner here is properly before the court. When Mr. Francisco was asked about that question, he went right to Vice President Vance. So I'd like to talk about why Vice President Vance's claim is moot, and there are two reasons. First, Vice President Vance has repeatedly denied having any concrete plan to run for office in 2028. Petitioners say that uncertainty is enough to prevent mootness. That's wrong as a matter of law. The heightened test for mootness that they invoke only applies when the mootness doctrine is being invoked to potentially manipulate the judicial system. Usually it's a defendant, sometimes it's a respondent, and usually that person is voluntarily stopping the conduct that triggers the injury. You made all this clear in your 2001 City News case, which is really on all fours here. There's no manipulation of the facts in this case, so Vice President Vance's claim is moot unless he has a concrete plan to run. Does he? Well, his public statements repeatedly, over and over and over the course of the past year, including in new comments that were reported this morning by NBC News, show that he has no concrete plan. If any other plaintiff in this court told you that his injury is speculative, that it's uncertain, that it's premature, that it might happen and it might not happen, they wouldn't have a prayer under Article 3. The same rules apply to the Vice President. There's no politician exception to Article 3. Even if you disagreed with me about Vice President Vance's standing because of his concrete plan to run, there's also the absence of any real-world credible enforcement threat. The executive order bars the FEC from enforcing the law. No one thinks President Trump is going to enforce this law and target his own vice president. And the Solicitor General's suggestion that private parties are the ones to worry about runs headlong into whole women's health, where you said that the threat of private party enforcement cannot create Article 3 jurisdiction. I'd love to talk about the merits as well and the radical nature of the arguments we heard this morning, but I also welcome the court's questions.
Well, before you do that, would you address the committees also in your mootness?
Absolutely. I think the committees are an easier case for us because the committees lack any ability. They had no statutory right to get out of the district court in the first place. There's a federal statute that governs who is allowed to take advantage of the expedited procedures, and that's Section 30110. It allows only 3 entities to go up in an expedited posture for mandatory en banc interlocutory review: the FEC, eligible voters, and the National Committee of the political party. The National Committee of the political party does not include the NRSC. You said that expressly in the DSCC case. You literally said that expressly after much discussion of the issue at oral argument. More importantly, the text of the statute doesn't allow it. FECA has a statutory definition that defines the term national committee, and it unambiguously refers only to, in this context, the RNC. It's not a surprise, given what I just said, that my friend on the other side did not address the text of the statutory definition until page 10.5 of his second reply brief in this case. They have no textual argument. Now, what he said was he's got a textual argument based on an amendment that happened 50 years later in 2002. Well, that doesn't work either. The statutory amendment that he's talking about only did not purport to override the definition. It didn't purport to override the DSCC case. So I think it's telling that when my friend got up and he was asked about the committees, he said, well, let's talk about Vance, because he thinks Vance is really the only way to get there. The committees also have other problems too. The enforcement issue is equally as strong as to the committees, and the committees can only have standing here if they actually have rights under this law, which they don't, because they need to rely on an invalid assignment regulation that doesn't survive Loper Bright.